Hello. If you've been arrested for a DUI in Chatham County in the state of Georgia, for that matter, one of the things that the police usually will give you at the side of the road, besides the actual citations, is what's called a Department of Driver Services Form 1205, and it looks kind of like this. You can see at the top it says Georgia Department of Motor Vehicle Safety. Now this will be a yellow, entirely yellow carbon copy sheet of paper, and at the very bottom you can see on this side it says temporary driving permit, and then you'll see it says DD form 1205 at the bottom. What this means is that you're going to be given 10 days from your date of arrest. Now these are 10 business days to actually request a hearing from the Georgia Department of Driver Services. If you don't do this, then an automatic suspension of your driving privileges or your driver's license itself in the state of Georgia could occur. So it's important that letter is sent off. Now, our firm usually does that. We send it off. It's a very detailed letter. It's about approximately 3 pages long. It doesn't have to be this long. If you actually look at the original form that you were given, on the reverse side it will contain the information on how to actually send the letter in. It's important to mail it certified, return receipt requested, if you're going to request a hearing, because you want to make sure that the department actually gets a copy of it and that you have proof. And just in case your paperwork or your letter gets lost in the bureaucracy, it's important that you have proof that you actually filed that in a timely manner, and the courts usually will honor those things. Now what will happen is after you send that letter in, sometime later on, usually a month or so may go by, where you'll actually get what's called a notice of a hearing. In this case it's in Chatham County, in the Chatham County Courthouse, and you'll get that in the mail. It's sent to the officer, usually to your lawyer if you have one, and also to you. And at that hearing, it's a very low level standard of proof. It's the lowest in the law. It's called preponderance of the evidence. You remember, this is not the criminal part of your case. This is the civil part. This is how the state of Georgia tries to suspend your license. They can do it 2 ways. One is administratively through this process, and the second way is either through a conviction of a DUI, either through a guilty plea, or if you actually take it to trial and lose. But in any event, usually the police officer will be there. They'll read off their police report and the narrative about what happened, how they came into contact with you, and at the hearing you're allowed to cross-examine police officers. You're allowed to ask them questions, very limited about what they did, how they came in contact with you, why they suspected that you were driving under the influence of alcohol. It's a very low level standard of proof. Now, defense attorneys typically go to these with the idea that these are very hard to win, because only a little bit of evidence has to be shown to the judge, and the judge can find enough to sustain the suspension of your license. The reason that we like them to go to them and file for these, number one, just honestly, if the police officer doesn't show up, then we move to rescind to the court. We say motion to rescind, judge, and basically that rescinds the petition, and it goes away, and it keeps our client's privilege to drive intact from then on, unless again they're found guilty of the DUI down the road, or they plead guilty to it. The number 2 thing that we try to use them for, honestly, is to find out the strengths and weaknesses of the officer's case. We cross-examine. It also creates a record. A record, usually it's in the form of a transcript. This is a bound transcript that we order, and the reason that, and it contains the actual questions and answers given by the officer, and it's sworn testimony, and we save this, and the reason we save this is that we want to put it in your file, and later on we can use it at trial. If the officer's testimony changes at all between the administrative license suspension and the actual trial of the case, then we can use this to what's called impeach that officer and ask questions about why that testimony changed. And that goes to the officer's credibility, goes to his memory, his ability to recall things. It goes to a lot of things. Very important to have a trial. Now, as I said, usually within 10 days they'll get an order out. The order is again sent to all the parties involved. By the way, I've just put this on there to block out my client's name just for privacy purposes, but you'll see a final order that will come through, and it just looks like this. either upholding the suspension or denying it. It's very important that this letter is filed. It's very important, and a lot of people don't know about this, um, to proceed in this manner, because if you don't do this, and if it's not done correctly, then it can seriously impinge your ability to drive in the state of Georgia. And as always, my office is more than welcome to sit down and go through this with you. Our phone number is 912-604-5387, or if you'd care to just look at our website, it's savannahjustice.com. And we're here to help you, and there is absolutely no initial consultation fee if that's what you try to do. All right, but thank you and good luck.